For today's discussion, we are discussing a recent plea by Jane Cavanaugh. If that name doesn't sound familiar to you, allow me to give you the story again. Jane Cavanaugh was a Marine. She served overseas in multiple different tours, and she was injured by a roadside explosive. When she came to the United States, she, like many veterans, had trouble adjusting. And she was able to get assistance and help, not only from the government, but also from interest groups such as the Wounded Warriors Project, who gave her money to help her, facilitate her transition into becoming a civilian and to get help for her medical needs. Also, because of a result of her exposure overseas, she unfortunately had developed cancer. So they were also able to help give her money in response to that so that she could get the medical treatments that she needed to help fight the cancer, get back on her feet, recover from her injuries, and otherwise, integrate better into society. Unfortunately, everything I said was just a lie. So Jane Cavanaugh didn't do any of those things. Jane Cavanaugh never served in the Marines. She never served overseas, and she was never injured. And she never had cancer. She claimed she did, and, the Wounded Warrior Project and all the rest was true, but not so much with Jane Cavanaugh. Jane Cavanaugh was just a faker. And she was a faker who submitted fakery to the Wounded Warrior Project and others and scammed them out of hundreds of thousands of dollars that was supposed to go to, disabled veterans. But she took it, claiming to have been injured, never having served. Incidentally, she is now pleading guilty to various crimes relating to this because the federal government wanted a piece of her. Let's read the plea deal of Jane Cavanaugh, who may be serving some prison time relating to the things I just mentioned. All right, so she's going to plead guilty to 4 counts: wire fraud, aggravated identity theft, use of forged military discharge certificates, and fraudulent use of military medals. Oh yeah, I forgot to mention that detail. The use of forged military certificates has a nice little additional bonus to it because she did work for the Veterans Affairs Administration, which is fine. You don't have to be a member of the military to work for the VA. They have lots of people who are not members of the military who work for the VA. So, she worked for the VA, that's fine. Unfortunately, one of the things she did for the VA was helping to process claim applications by actual veterans. And, she got to see actual claims by actual veterans actually submitted. And so she just took one of these at one point and just, did a little photoshopping and replaced some names, and now it's her certificate. And every time that she was asked to basically validate her story, she knew exactly what to do. Because she had seen so many of these legitimate things. She knew what a legitimate thing looked like. She knew what legitimate records looked like. She knew what legitimate claims looked like because she processed them. So she was able to construct a pretty convincing forgery because she knew what the legitimate ones looked like. So that would be the use of the forged military discharge certificate, where she just took some guy's certificate and just made it hers. Defendant further agrees that between filing the time of the plea and scheduled date is excludable under Speedy Trial Act. So Speedy Trial Act is not a problem. She's waiving that part, which you can do. Defendant will promptly submit to a completed Department of Justice financial statement to the U.S. Attorney in a form to be provided and directed by the U.S. Attorney. Defendant agrees that the financial statement disclosures will be complete, accurate, and truthful. We'd like to know how much money you have so that we can get to some of it. Defendant expressly authorizes the United States Attorney's Office to obtain a credit report in order to evaluate her ability to satisfy any restitution. Great. Defendant agrees funds in the amount of $82,489. Her proceeds from sale of her real estate will be applied towards restitution and other financial obligations. Unfortunately, the amount of money she took is more than $82,000, but I guess it's better than nothing. So we're going to use the sale of her real estate, which was about $83,000, as partial financial restitution to compensate for giving her money that was basically stolen away from the disabled veterans. Defendant has provided this check to the U.S. Attorney's Office. At sentencing, the U.S. Attorney will provide the check to the clerk of court for application of any financial obligations. Defendant acknowledges, although the final sum has not yet been determined, it's anticipated the sum will exceed this amount. I would think so, because the amount of money that she's taken is in excess of $82,000. So it's like, yeah, this is probably not all we're going to need. We're probably going to need more money. Yes. Should, however, it be less, which seems incredibly unlikely, we're going to keep it all anyway as forfeiture. Incidentally, at this point, this is criminal forfeiture, not civil forfeiture, right? Because we're in a criminal case. So whatever problems anyone has about civil asset forfeiture, and there's many reasons to have many problems, this is not that. This is criminal forfeiture. You are giving up the money that you got as part of the fraud because you can't keep it, in addition to other penalties. So, yeah. So in the unlikely event that it's less than the amount you gave us, we're going to keep it all anyway. That's fine. In exchange for the plea of guilty, here's what the government is promising, and it's not very much, incidentally. The government will recommend the court impose a term of imprisonment at the low end of the guideline sentencing range for the offense level determined by the court. All right, so there is a sentencing guideline which has about 250 different boxes. These boxes are determined by how severe the offenses are, right? So there's how severe what you did now is, and how severe all the things you've done in the past are. How bad have you been in the past, and how bad are you now? These are the box grid, right? It appears she has no criminal history. So she has not done bad things in the past. So she's in history category number 1. So then it just becomes a question of how bad is she now? Where on the table do you fall, right? Once you make that determination, it's going to give you a guideline range of years, right? It's going to be something like, and these are just random numbers just to illustrate the point, it's like something between 84 and 104. Just as an idea, right? So the U.S. government, without committing to what the guideline range is, right? So they're not committing to the guideline range. They're just saying that whatever the guideline range winds up being, we'll commit to recommending something on the lower end of the guidelines. But we're not committing to what the guidelines are. So we don't know. We're on the lower end of the range. We're on the lower end of the range. We just don't know what the range is yet, at least in terms of the plea. Or the mandatory minimum term of imprisonment pursuant to statute, whichever term is greater. All right. But not including probation or split sentence, even if permitted. So we are not going to agree to any kind of probation or any kind of split sentencing. This is how far we're willing to go. We will commit to recommending the low end of whatever guidelines range you fall into, which, given the scope of things you've done and the fact that you are being convicted of 4 different offenses at the same time, the guideline ranges might be a little bit higher. So, but we'll see. It could be a lot of different things. For the purpose of determining the offense level, the government agrees to recommend a 2-level reduction of the offense level for acceptance of responsibility. This is very typical. It's one of the things the government does to encourage you to plead guilty. It's like, we'll give you a little bit lower of a break because you're pleading guilty and saving us the time of having to go to trial, the time, expense, and all the rest of it. It's not much, but it's a little bit. It's a 2-level decrease. It's very, very typical. Okay. At the day of the agreement, defendant has timely notified authorities of intention to plead guilty. If the offense level is 16 or greater, and they enter a plea pursuant to this agreement, the government will move for sentencing for an additional decrease of 1 level, as an additional break. So, fine. The government is free to recommend any combination of supervised release, fines, and restitution which it deems appropriate. So, while we are committing ourselves to recommending the low end of the guidelines, whatever they wind up being, we have made absolutely no commitments when it comes to auxiliary things, such as what your supervised release will look like, what your fines will look like, what your restitutions look like, right? We're only committing to making recommendations relating to your prison sentence, not this other stuff. Defendant understands the guidelines are not binding on the court, which they're totally not. The court can ignore them. And although the court must consult the guidelines in fashioning any sentence in this case, the guidelines are only advisory, and the court may impose any reasonable sentence in this matter up to the statutory maximum after considering the factors. Yes, so the guidelines are no longer mandatory, and this is a promising thing because they were too constrained. The U.S. Supreme Court changed this quite a few number of years ago at this point. I'm not even sure, like 15 years ago, they changed this. It's been a while. But they used to be mandatory, now they're not, which is a good thing, in my opinion. So yes, the court can look at this and say, okay, well, I've done all the factors that determine the guidelines, what the guidelines range are, but they are guidelines, right? This is Pirates of the Caribbean. They're not so much rules as they are guidelines. Exactly so. So the court could go lower than the guidelines. They could go lower than the lowest bound if they want, or they could go higher than the higher bound. The sentencing is in discretion of the court. And so this is just a reminder to them. It's like, hey, by the way, although we are recommending a particular sentence, the court can ignore us. And sometimes they do. And you can't complain because your deal is with us, not with the court. So we'll do our part, but if the court comes and whacks you over the top of the head, that is distinctly not our problem. Right. Okay. Then there's some stipulations as to some aspects of the guidelines. So they say, okay, as to count one, the total financial loss incurred was more than $250,000, but less than $550,000. This seems correct based on everything we know. So we are stipulating to that aspect of the guidelines. And we're also stipulating that the offense involved 10 or more victims. Those are both enhancements, as you would expect. So we're stipulating to those aspects. But incidentally, we are not stipulating that there are no other aspects that apply. We're stipulating these aspects apply. But as to other aspects, we could say other aspects apply. Other guideline range applies is, right? We're not even saying what the guidelines are. We're just saying that whatever they wind up being, we'll give the lower end, but we're definitely agreeing to these enhancement factors. Except as expressly provided, there is no agreement at which the offense level or history applies in this case. Both the United States and defendant reserve the right to argue and present evidence on all matters. So again, there is no agreement from the United States attorney as to what the proper guidelines is. Sometimes you will see that, right? We will recommend a guideline of this number. Again, that is not necessarily binding on the court, because the court might find a different guideline number on top of ignoring the guidelines completely, because the court has to first determine what the guidelines are, which is operation of law, and then determine whether or not to sentence you within that or not, which is basically within the sentencing discretion of the court. And then you're just into an abuse of discretion analysis, which is pretty hard. But here, the United States government is not saying we're committing to any sort of guidelines. We're not committing to any sort of category. We're not agreeing as to the criminal history category, although it's almost certainly one, but we're not agreeing as to the offense level. So we can recommend any offense level we want. Whatever offense level we ultimately get will include a range. Again, whatever that range is, we'll recommend on the lower end of the range, but we're not promising any particular range. Right? So it's like, well, so there's a lot here in terms that are uncertain as to the future of this that seem beneficial to the U.S. government. They are leaving themselves open a lot of options. So by pleading, she's not getting very much for the deal, at least in terms of the formal plea. She's not getting very much for it in terms of comparative pleas we've seen. But that's okay. You can agree to any plea you want. And she's agreeing to this one. So then they just remind you what the maximum possible penalties are, because it's like you need to know what the maximum is. These are the limits. Under count one, 20 years, 3 years of supervised release, and a fine of $250,000 is possible. Under count two, a mandatory minimum of 2 years. So we know you'll serve at least 2 years, no matter what happens, because it's a mandatory minimum. Consecutive to any other sentence imposed. So it's 2 years plus whatever, plus this is not a maximum, it's a minimum. Right? So you will serve at least 2 years. You will serve those 2 years on top of any other sentence. And it might not be 2 years. It's at least 2 years, but it might be more. Probably will be more. We agree to count three and count four as to those elements, 1 year imprisonment and a fine of $100,000. It's not a very aggressive penalty, but that's what Congress provided for. So be that as it may, right? If imposed consecutively, so this would be the worst possible case, the maximum penalty for all the offenses of pleading guilty are 24 years imprisonment, a fine of $450,000, and a term of supervised release of 3 years. And then also a special assessment of $250 if you care. I'm not sure where these special assessments come from. They seem so de minimis. It's like, who cares? But we'll inform you of it anyway. So theoretically, there's a max of 24 years plus $450,000 in fine in terms of supervised release of 3 years, which a judge could theoretically sentence you to if they find a reason to deviate that hard. There almost certainly is not, but we need to let you know what's possible because sentencing is within discretion of the judge. Defendant agrees that after defendant and defendant counsel sign this plea, counsel will return it along with the money order or certified check we discussed above. Failure to do so, unless the court has made a finding of indigence, will relieve the government of its obligation. So you have to give us the money and a check, and you have to give us the plea in order for us to agree. And then we're going to go through the rights that you're waiving to make sure this is a knowing, intelligent, and voluntary agreement under law, right? So here are the rights you're waiving. You have the right in a prosecution for perjury or making a false statement. The government has the right in a prosecution for perjury or making a false statement to use any statement you give under oath. So in the event we want to charge you in the future for perjury or making a false statement, just to let you know, if you're making any false statements, we got to use those against you in a future proceeding because you're making them, under oath and all. So, there's that. Defendant has the right to plead not guilty or to persist in the plea of not guilty. Defendant has the right to a jury trial. Defendant has the right to be represented by counsel and, if necessary, have court appoint counsel at every stage of the proceeding. Defendant has the right to confront and cross-examine adverse witnesses, be protected from self-incrimination, testify and present evidence, and to compel the attendance of witnesses. Defendant waives those rights if the court accepts the plea. So, these are the rights you have that you're giving up, just to remind you. Defendant recognizes pleading guilty may have consequences with respect to immigration status if they're not a citizen of the United States, which they are, but, we got to inform you anyway, just to be, safe. Okay, and then, just to remind you that, it could impact your immigration status, but it doesn't. The government reserves full right of allocution, including the right to present any information to the court for consideration in fashioning an appropriate statement, the right to make misstatements, misrepresentations, or omissions, or answer any questions by the court. So allocution is the process by which the defendant says what they did that was bad. That's allocution, right? So the court's going to ask you, hey, what bad things did you do? And you're going to say the bad things that you did. That's allocution. But the government also gets to participate in that process because the government also might have some thoughts as to the bad things that you did. And they might want to offer those thoughts in the allocution if you are less than forthcoming. So they are just reserving their right to also add to the richness of the allocution if required. Except as agreed above, the parties have made no agreement concerning application of the guidelines. Defendant understands this is the key. This is a key part of the plea. Defendant understands the court alone makes all sentencing decisions, including the applicability of the guidelines and the sentence to be imposed. The court is not bound by the parties' stipulations of facts, offense level adjustments, or the government's recommendations. The court is free to impose any sentence it deems appropriate up to and including the statutory maximum. Defendant also understands that even if the court's guideline determination sentence are different than the defendant expects, defendant is not allowed to withdraw the plea. Right? This is the sort of big ass thing that people sometimes people forget. And we want to make sure you really understand this, right? Your agreement in a plea, your plea is with the government. That is the executive branch, right? The executive branch is the one that is suing you, which is technically the proper term for this. Although you would normally think prosecution, but suing you if you like. Either way works. It's a criminal suit, but still. Anyways, either way, they're the one prosecuting you. They're the one that's the adverse party in this, right? It's the United States of America versus Kavanaugh. So they're the adverse party. So they can make agreements or not, but they can make agreements, right? They are the executive branch. An entirely separate branch of government exists called the judicial branch. The judicial branch is not part of the executive branch. So the executive branch, unsurprisingly, cannot make agreements that are binding on the judicial branch, right? It's So the judicial branch is an independent actor in this. That's kind of the idea. They're literally the independent actor. They're literally the judge. So the executive branch can't bind the judge because that would be dumb. The executive branch can only technically make recommendations. So look, here's what we're agreeing to. Here's what we're not agreeing to. And we've read plea deals before in which the government agrees to do more. It's not uncommon that they'll agree to recommend a particular guideline range or a particular sentencing factor, or they'll say, here is the exact number. But still, like, even if they do all those things, which is not atypical, right? Still, the court does not have to accept it. Like, even though we are both agreeing, sentencing is within the discretion of the judicial branch. So once you plead guilty, the executive branch's participation in this is kind of a little bit over, or more tangential, I suppose, because now your ass belongs to the judicial branch, and they might have separate thoughts. These thoughts may or may not conform to your expectations. If these thoughts do not conform to your expectations, too bad, so sad, you already pled guilty. So you can't withdraw your plea. So, you take your chance. You take the chance. The judge might just say, you know what? I don't agree with any one of you. That's part of the deal. Defendant hereby waives defendant's right to appeal the conviction and sentences imposed by the court if the sentences imposed are within or below the guideline range determined by the court. But still, whatever the guideline range is, the agreement does not affect the rights of the United States set forth in law, and the government retains the right to appeal any of the court's sentencing determinations. So in the event that in the event that the court goes way off the reservation and goes way too low or something, the U.S. government can also appeal. Both sides can appeal the sentence, right? It's hard for either side to appeal because it's within the discretion of the court, but it has to be within the bounds of reason. It has to be reasonable, and then you're in an abusive discretion analysis, which is tough. But sometimes it's so low that the Court of Appeals says that's too low. It was an abusive discretion to go that low. That's happened. And the reverse has also happened, where it's so high, it's an abusive discretion. But if it's anywhere within sort of a 90% middle range of reasonableness, if reasonableness is on a 0 to 100% scale, if we're in a middle 90%, the court can kind of do anything it wants in that ballpark. There's a lot of discretion to the trial judge. This is incidentally one of the reasons that I make a point of noting that rule number 1 of litigation is don't piss off the judge, because the judge has a lot of latitude. And so they might do a lot of things that could potentially burn you if they're not your friend. So you might not want to try to piss them off. This agreement is binding on the government only if defendant pleads guilty, fulfills all your obligations, does not exchange in conduct that would be obstruction of justice, and doesn't commit anything new offenses. Defendant understands that if the defendant violates this agreement, the government shall be released from its obligation and be free to make any recommendations. If that occurs, defendant shall not have the right to withdraw the guilty plea. So in the event that you obstruct us or commit new crimes, we are completely free of all these obligations, but you're not. Right? It's your breach. It's your breach, not ours. So we get to determine the remedy for the breach. Right? And the remedy is we're free, but you're not. So probably don't want to do that. Yeah. This agreement is limited to the District of Rhode Island and does not bound any other state, federal, or local prosecutive authorities. There probably is no other federal authority that has jurisdiction, although I wouldn't necessarily put it past them. I mean, there might be certain jurisdiction somewhere else in some other federal authority. District of DC comes to mind, possibly, but probably not. Probably is limited to Rhode Island. So this might be the end of her federal exposure, although in the event that some other federal district other than the District of Rhode Island has jurisdiction for some other reason, this plea doesn't bind them. So if you've committed some other federal offense in some other jurisdiction, this plea does nothing for you. Also, incidentally, anything you're saying in this plea can and will be used against you in a court of law. But perhaps even more to the point, she absolutely has exposure under relevant state laws, right? She committed a bunch of federal offenses, to be sure, like the wire fraud and the misuse of military medals and the misuse of military forms and so forth and so on. Those are federal interests. But she committed just like fraud against these people, like just normal fraud. And so she committed things that are in violation of possibly several states' law. And this plea absolutely does not bind any of them because they are separate sovereigns. And also, incidentally, your plea deal here and your plea of guilty and anything you say as part of that plea can and will be used against you in any other court of law. So if the various states want a piece of your ass, they get to use all your admissions, including the plea deal itself, which itself is an admission, by the way, including anything you say, including any allocution you say, and this plea does jack all with respect to that. So your criminal exposure in other jurisdictions is going up, and we're doing nothing to stop it. Not that we could anyway, because they're separate sovereigns. We're just letting you know. So yeah. This agreement is the entire agreement. No other agreements exist. No one has promised anything else. This is it. This is all we've promised. And it's not much. Counsel for defense has explained all this. Defendant says they understand all this. Signed. Done. So, yeah. So Sarah Cavanaugh is going to jail for some period of time. So that brings us to the end of Sarah Cavanaugh, quite possibly. Sarah Cavanaugh is going to prison for some period of time. I've seen news articles that say that she's going to jail for 2 years and that the U.S. government is, going on the low end of the range. People are misunderstanding the nature of the plea. It doesn't say that. It says at least 2 years because there's a statutory minimum. And then the court, and they have to tell her that. Like they have to tell her like any minimum and any maximum. They have to tell her the range of what's possible. So it's like, well, one of the things that's possible is one of the things that's required actually is that you'll get at least 2 years. You can't get anything more than the maximum and you can't get anything less than the minimum, which in this case is 2 years. So like, yeah. So how much term will she get? Well, it's kind of unbounded here, and there's a lot of different offenses and there's a lot of different things to calculate. So I don't know quite how much time she's going to get by the federal government, but it's definitely going to be more than 2 years. It won't be 24, I'm quite sure. But it's going to be some number of years in federal prison. And if that wasn't enough, her exposure for various state level offenses is very real. Because, for example, the Wounded Warrior Project, which was defrauded, might have some thoughts that it wants, which could of course be in the form of a civil suit. But they might want to, for example, go off to their friendly district attorney and be like, hey, friendly district attorney, have you considered charging them for fraud? And so there's definitely some possibilities there. So her exposure is increasing. Fake Marine, fake wounded, fake medal wearing, fake Purple Heart woman who went on and just defrauded like the Wounded Warrior Project and several other organizations to the tunes of hundreds of thousands of dollars is going to jail for some period of time and faces additional exposure. And that, for the moment, brings us to the end of discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. Until later, my friends, cheers and goodbye.